Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On or about September 19, 2024, an officer conducted a follow-up in regards to an assault on a family case. Upon further investigation, the officer made contact with the complaining witness, who reported that the defendant had been harassing her since September 18, 2024, by sending her videos, voicemails, and text messages containing horrible remarks, approximately 50 to 60 messages in total. In the voicemails, the defendant curses at her, asking, "Where are you? Why the fuck aren't you at work?" and calling her various names. Additionally, the complainant showed the officer text messages of the defendant telling the complaining witness, "Kill yourself and I want to watch you suffocate, and your family hates you." The complaining witness indicated that the continual harassment is making her fear him even more. Complaining witness was able to give officers the defendant's identifying information and positively identify the defendant as a person who has been harassing her.
I see that he has also picked up a felony.
This is a slow burn nightmare that escalated from text messages to bruises to absolute fear. What you're about to watch is a judge who immediately recognizes something dangerous standing in front of her, and it's not subtle. This defendant isn't just accused of sending messages. We're talking dozens of voicemails, threats telling someone to kill themselves, and violence triggered by something as small as socks not being in a drawer. That detail matters because it tells you everything about control, volatility, and unpredictability.
Assault against this complaining witness as well.
Yes, sir.
Okay. What happened in that one? And I'm assuming it's the same date as this one, so I'm assuming it's out of the same transaction.
I'm not sure. So it says that I don't believe so. It says that on September 18th in Harris County, officers were dispatched to an assault. The complaining witness advised that the defendant came home upset about socks not being in the closet. The defendant punched the complaining witness with a closed fist on her foot twice on her right thigh and twice on her left thigh, causing pain. The complaining witness advised that the defendant grabbed her by the arm and forcibly shoved her out of the house, throwing her on the porch. She advised that she felt pain, and she advised that this has been an ongoing issue for the past 2 years. The officers observed purple and green bruises on her arm, foot, and her legs. The bruises were green, purple, and red and of significant size.
Is there a no contact order in this case?
Judge, who's the defendant?
This is Mr. Fritter. He hasn't harassed, Mr. Fritter, let me tell you something now. You scare me. And you scare me something good. You have, since 14, assault, trespass, deadly conduct, assault, DWI, forgery, and now.
When the officer mentions 50 to 60 messages, that's not a throwaway detail, that's a pattern. Courts don't look at harassment as a single bad text. They look at repetition, escalation, and intent. Videos, voicemails, texts. That's 3 different methods used deliberately. And when you hear phrases like "kill yourself" and "I want to watch you suffocate," that crosses a line from harassment into psychological terror. This isn't venting. This is intimidation. It's meant to instill fear and control, and the complaining witness makes that clear when she tells officers she's afraid of him.
Harassment and a felony assault.
Judge, there has been a note filed, but there is no protective order in this case.
Is there no contact in the felony case whatsoever?
I'm checking the law conditions. It's no threatening or harassing at this time. Would ask if that be a no contact in this court, Judge.
I don't see that the rip has been.
Are you Miss Lisco?
Yes, sir.
That's Miss Lisco, right? There. Come up, ma'am. Come up. I'm sending you for a drug and alcohol test right now, Mr. Fretter. I want to protect you as much as I can. No one has to have this kind of treatment whatsoever for any reason. And I will do everything in my power to protect you. All I need you to do is tell me, All I need is please give me the word. Mr. Fritter, look at me. You so much. One, I'm. Can you imagine what life is like when someone has to walk on eggshells because they have the fear that if they make someone mad in the smallest respect of having socks not in the damn drawer, they're liable?
This is the moment the courtroom temperature changes. Socks not being in a drawer. That's the trigger. And what follows is closed fist strikes, bruising across multiple parts of the body, and being forcibly thrown out of the house. That detail matters because it shows disproportionate response, a hallmark of abusive behavior. The officer doesn't just report pain. They document visible bruises in multiple colors, meaning injuries at different stages of healing. And when the witness says this has been happening for 2 years, that's not an incident. That's a cycle. Judges hear a lot of excuses. But patterns like this are hard to ignore.
To get a beating, can you imagine what life is like to live with that kind of fear? You're going to live it with me now. Because one false move, I'm going to make your bond so high your head will spontaneously combust. But no one, and I mean no one, should have to live with that kind of fear. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. And I don't know if I'm going to allow you to have contact with Miss Lisk. But if I find that you treat anyone or put anyone in fear or put anyone in harm's way, so help me, I will grow horn and tails because I will be so upset. And it will be on you. Do you understand?
Yes.
Abel,
Yes.
I'm going to keep Mr. Freder so close to me that it's just ridiculous.
Yes, sir.
I'm entering what's called a magistrate's order for emergency protection. This is a court order that identifies her as a protected individual. You're not to have any kind of communication whatsoever.
When a judge says, "You scare me," that's not theatrical, that's judicial instinct. Judges are trained to assess risk quickly, and that statement tells you she sees volatility, escalation, and unpredictability all at once. His criminal history adds weight. Multiple assaults, DWI, forgery. This isn't an isolated lapse in judgment. It's a trajectory. Courts don't just punish past behavior. They try to prevent future harm. And right here, the judge is signaling that she sees this defendant as someone who could seriously hurt someone if unchecked. That's why everything that follows becomes about control, monitoring, and protection.
You're not supposed to have you will not have any threatening or harassing contact. What is threatening or harassing doesn't matter what you think is threatening or harassing. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is. And it's enough for me to put you in jail and make your bond $150,000, maybe 50, maybe 20. But I will do, Mr. Freder, I will do everything in my power to protect every single person of this county. And I don't care if you're kicking, screaming, crying because you go to jail and don't have anyone to bond you out.
That's a question. Your husband and wife of 10 years, this is kind of difficult situation that we live together.
I want to protect you, ma'am. And you know, the problem is that now that he's picked up these 2 cases, times will be just even more stressful. We have these protective orders. They're basically like cooling off motions so that, you know, you can separate enough time will pass.
This speech cuts straight to the reality of domestic fear. Walking on eggshells isn't poetic language. It's lived experience. The judge reframes a case from legal charges to human impact. A home where socks can trigger violence isn't home. It's a threat environment. When she says, "You're going to live it with me now," that's the court asserting dominance over chaos. She's telling the defendant, "Your unpredictability ends here." Judges rarely personalize supervision like this unless they believe constant oversight is necessary to prevent harm. This is the bench stepping in as a barrier between fear and survival.
So they're not under the stress of the excitement and then unleash on you. The last thing I want is for you to suffer any kind of harm whatsoever, and I that's all I want. All I'm asking is how things should be normal. Like, I'm not asking him for him to do Pythagorean's theorem here. So, I don't know. What I'd like is if you please just talk to our DAs here. But I'd like you to have their phone number at the minimum so that should anything ever whatsoever, all you have to do is let us know. And then
I have been in contact with the DA, so should it be assault?
I'm here for you. And I want to make sure that you're okay. I've given him a lawyer. He knows what's expected of him. And I'm going to drug test him like crazy to make sure that he's not using alcohol or dope. In fact, I'm going to test him 2 times a week. I'm setting him now because I want to know what, if anything, is in his system, and then we'll go from there.
Judge, he will come back positive, but that's prior use from.
What were you going to test positive for, Mr. Freder?
Marijuana.
Okay.
And ketamine, and probably some other stuff that could have been in the ketamine.
This is one of the strongest tools a court can use early on, an emergency protection order. Notice how the judge removes ambiguity. It doesn't matter what the defendant thinks is threatening. Perception controls compliance. That's intentional. Abusers often exploit loopholes and technicalities, and the judge shuts that door completely. Even a gesture can land him in jail. She's setting a zero-tolerance framework, and she backs it up with bond threats that are deliberately extreme. This isn't about punishment yet. It's about deterrence.
But, straight up, that's probably it.
Mr. Freder, I'm going to test you. These are your bond conditions that are going to apply to you now. And if you fail to live up to these bond conditions, I'm just going to let you know. That's it. You will appear to me here 2 times a week to take drug tests. And if I find anything is in your system, and I don't care what it is, I'm going to lock you up. You're ordered not to use any kind of dope or alcohol. And if you can't get this monkey off your back, because I am now giving you the opportunity to do it on your own. If you're incapable of doing it on your own, then I'm going to do it for you. Do you understand? No dope, no alcohol. And when I mean no alcohol from any source. No isopropyl alcohol, cakes, candies, foods, gums, energy drinks, tequila, lollipops, hair dye. I've heard it all, and I don't care. You come to me test positive, you'll stay with me. I also want you 3 times a week to do anger management classes so that we can deal with the anger issues. Look at me. 3 times a week. And I want a piece of paper showing me that you've done it, the date, time, location of where you've done it, so that I can verify that you've done it. And if you don't do it, you will stay with me. You now have the opportunity to address these things on your own. If you don't, you will be doing it with me. And if I get one breath that she's been mistreated in any way, shape, or fashion, holy freaking moly. And then, ma'am, if you'd be so kind, please, I'll have you speak to them here momentarily. Rachel, this is my card. If you ever need anything, all you have to do is get in contact with me.
The moment the defendant admits ketamine use, everything clicks into place. Volatility, aggression, impaired judgment. Substance abuse doesn't excuse violence, but it explains risk. The judge's response is swift and surgical. Constant testing, absolute sobriety, no loopholes. Even products with trace alcohol are banned. That level of specificity tells you she's dealt with manipulation before. This isn't rehab, it's containment. The court is saying, you don't get the benefit of the doubt anymore. Every test becomes a tripwire. This case is a clear example of the justice system stepping in before tragedy strikes. The judge recognized escalating danger, documented abuse, substance involvement, and fear, and responded with aggressive oversight, protection orders, and accountability. This wasn't about anger in the moment. It was about preventing irreversible harm. The message from the bench was unmistakable. Intimidation, violence, and fear will not be tolerated, and excuses won't save you.